Those who are not in favor of the motion, those who are not in favor of the motion, please raise your right hand.
Against Chief Justice Corona. This representation has attended since 2007, 4 impeachment complaints, which I have been a member of this committee since 2007. The first complaint was against the President, GMA. 2007, I was new, dismissed. Then we have Gutierrez, Residita, she resigned. And then we have Corona. On record, Madam Chair, precisely, this representation voted no to the Corona complaint because to me there was no sufficiency of substance. And in the resolution of the House of Representatives, I voted no. In the Senate, it proceeded because the majority, of course, with the President at the time pushing for that, he was therefore impeached. In other words, the proceedings there are completely different now. I don't know that during the time they allowed it, but here our chairman is making sure that we follow the requirement of substance, that there should be sufficiency in form and substance, and there should be recital of facts. Well, in that particular case, I lost. I was against it. It proceeded. But I voted no. I did not want Chief Justice Corona to be impeached. Later on, it has come out that there have been lobbies with senators to impeach Corona, you see. So, therefore, that is what happened before. But now, Madam Chair, we are with you. You are presiding this very well. And we want to have the real recital of facts constituting the offense charge. And certainly, based on this, and based on the complaint, and based on the annexes, wala. Now, a new matter is injected by our friend, Congressman Ridon, stating about SALNs of 2023, 2024. Is that particular SALN, has that been authenticated by the Ombudsman? Do you have a copy of authentication of the Ombudsman?
I don't.
Honorable Ridon?
I don't think that is required. It is public record, Madam Chair.
Well, there's no automatic authentication, public record, all the records. There has to be authentication. When you go to a proceeding like this, it's the Justice Committee of this country, of the House of Representatives.
Madam Chair.
You cannot just state that it's a public record. Now, where is it? Where is it? Is it found in the complaint? Because we are limited, Madam Chair, to the complaint and to the annexes. Here we are. Here we are. We're limited with this. To inject something based on the statement, and there is no authentication that we have, there is no such thing as automatic authentication. In any proceeding, you have to authenticate.
No,
so therefore, there can be,
Madam Chair.
unless there is an authentication and the Ombudsman has already certified that, we cannot take cognizance of that particular injection of this new matter in the hearing. Thank you, Madam Chair.
Just to be clear,
Honorable De Lima first, and then Honorable
excuse me,
Po, and
Madam
then
Chair.
Honorable Ridon.
Authentication can be done at the evidentiary stage. No need for authentication at this point. The committee can subpoena, can request copies of those SALNs from the official custodian, the Office of the Ombudsman. So authentication at this point is not needed. Thank you.
I disagree, Madam Chair. May I be just one sentence? Our
Proceed.
verification. I will read now the verification. Verification of this. What does it say? In the verification of the
Personal
complaint.
knowledge or authentic records.
Yes, precisely. We have to have ultimate statement of facts, personal knowledge of the complainant, Attorney Cabrera, and then, of course, here we go. I will read now the verification of Attorney Cabrera. Aha.
I think it was just
Allegations-
one sentence, Madam Chair.
Let
This
us
one
wait.
sentence.
Let us
So
wait
this is my last
until
sentence.
he finishes with his
No, that's 3
manifestation.
sentences already, Madam Chair.
My 3 sentences is considered as one sentence.
All right, Madam Chair.
The allegations Number 3, the allegations in the complaint are true and correct based on my personal knowledge or based on authentic documents. See? That's very clear. Nobody can debate with that. And if Congressman Ridon says this is authentic, that is his word. We have to get authentic documents signed and duly certified by the Office of the Ombudsman.
Yes.
Thank you, Madam Chair.
Honorable
That is
Rodriguez,
5 sentences, but consider
that was one paragraph already. The Honorable Ridon.
Madam Chair, it's a very basic question. That is an irrelevant response. You know why? Because firstly, I am not the complainant. I am not bound by the verification. Hindi ba? Why are you talking about authentic records? I am speaking as a House member and participating in the House Committee on Justice. The point is not on point, Madam Chair. And my question is basically, are we being challenged that what is being presented is actually not the true representation of the SALN of the Vice President for 2023 and 2024? Kasi parang ganun ho yung dating. And more importantly, dinabas ho ito. Nakita ho ng bayan, yung 88 million
Madam Chair.
nalaman po ng SALN. So, tingin ko that should not be considered, Madam Chair.
The Honorable Po, and then the Honorable Suntay, and then the Honorable Dilima.
Madam Chair, so we can move forward already. I just want to clarify for the body whether or not the Honorable Congressman Rufus Rodriguez is asking us to ignore the silence that were presented earlier. Is that what we're being asked?
That is precisely to answer. Can I answer, Madam Chair?
You're recognized,
You
Honorable
cannot inject
Rodriguez.
anything not found in the complaint and the annex. Because then the requirement that Attorney Cabrera, is of personal knowledge and or authentic, that is very clear in all verifications. Authentic.
We go back to Honorable Po.
Well, then, to that point, I believe that we should move into merit so that that can be admitted as part of the evidence, in
Madam Chair,
in this situation.
well, he's right to ignore it, but Madam Chair, just one last
Yes,
one.
you may
point.
proceed.
Well, he's right to ignore it, but firstly, he was challenging the availability of public records. So we were submitting the public records actually available. And secondly, I'm not asking that it be made part of the complaint. This is being submitted for the consideration of the body that it is untrue that public records relating to SALN, unexplained wealth, do not currently exist. It exists. And we had been submitting it for the record, Madam Chair, irrespective of whatever documents that had not been submitted by this complaint. Madam Chair, I submit.
The Honorable Suntay.
Thank you, Madam Chair. Well, Congressman Ridon stated two facts. First, tama yung sinabi niya, he's not a complainant, but he's trying to introduce new documents which he wants us to consider. Second, the document he is trying to introduce is not to the knowledge of the complainant. So, we cannot consider it here because it's not part of the complaint.
The Honorable Dilima.
Thank you, Madam Chair. Nothing prevents this committee from directing the production of SALNs as essential documents in determining the facts of these proceedings. Impeachment is sui generis. We have all the plenary power or authority to do that, just to arrive at the correct conclusion, just to substantiate and establish the necessary and essential facts. That is my position, Madam Chair.
Just like any other manifestation of the justice members, the document presented by the Honorable Ridon forms part of his manifestation. And
Madam Chair.
therefore, all of your manifestations, including the documents which were shared, will become basis of the judgment of the justice members in determining the sufficiency in substance.
Madam
That
Chair.
might not be introduced as an evidence yet, but that might be introduced as part of the manifestation of the Honorable Ridon. The Honorable Padiernos.
Thank you, Madam Chair. So I'd just like to point out in our rules of procedure in impeachment proceedings, under Section 7, Kasi pag-usapan po natin yung mga SALN and other documentary evidence. So it says here that the committee shall have the power to issue compulsory processes for the attendance of witnesses and the production of documents and other related evidence. So ibig sabihin po nun, again, at this stage, we're just merely looking at the recital of facts, whether it constitutes an impeachable offense. So I would just like to proceed with my manifestation. So Madam Chair, on Article 5, the committee's task is not to decide whether the respondent actually has unexplained wealth. The question is whether the complaint pleads a coherent theory of liability supported by alleged facts, which, if true, could amount to an impeachable offense. As pleaded, Article 5 alleges that public records and financial leads point to assets and financial movements inconsistent with lawful income and allegedly not fully reflected in SALNs, which, if assumed true, raises a serious accountability issue under the SALN regime and supports a theory of betrayal of public trust. Kaya lang po, meron po tayong case. I just wanted to also share with the committee the case of Salig, where the Supreme Court held that it cautions that errors in SALN do not automatically equate to dishonesty, absent intent and due process. Kasi na-mention din po kanina, it's unfair daw po na kung merong hindi na banggit sa SALN ay automatically liable na dapat yung impeachable officer. So those considerations are matters for later stages. Again, hindi po natin sinasabing guilty ang ating impeachable officer at this point in time. We are merely looking at sufficiency in substance, yung which later on, pwede po mag-submit yung ating impeachable officer or respondent ng kanyang mga defenses. So at this stage, the pleaded allegation is that the omissions are material and linked to unexplained wealth indicators, which it would appear would be enough to cross the threshold of sufficiency in substance. Thank you, Madam Chair.
Madam Chair.
Thank you. Honorable Zamora.
Thank you, Madam Chair. 2 points. First, this is regarding the ultimate facts that must be alleged in a complaint. And this goes for all of the allegations in the impeachment complaint. Salita versus Honorable Magtalis, GR number 106429, June 13, 1994 states, a complaint only needs to state the ultimate facts constituting the plaintiff's cause or causes of action. Ultimate facts has been defined as those facts which the expected evidence will support. As stated by private respondent, this term does not refer to the details of probative matter or particulars of evidence by which these material elements are to be established. It refers to the facts which the evidence on the trial will prove and not the evidence which will be required to prove the existence of those facts. Second point, Madam Chair, we were discussing lengthily about the public documents, the SALN. Public documents follow the self-authentication rule. They do not need further authentication. They should be enough, and their existence as public documents is by itself their authentication. Thank you, Madam Chair.
Honorable De Lima, would you like to make manifestation?
That is exactly my point also, Madam Chair, about the
All right.
self-authentication rule relative to public documents. And SALNs are public documents. When we're able to get them, they are public documents. Thank you.
I think we have made an ample exchange of arguments in as far as SALN is concerned, but I wish to reiterate that while it is true that we cannot introduce evidence at this stage, those SALNs which were flashed by the Honorable Ridon forms part of his manifestation. And therefore, just like any other manifestation of the rest of the members of the Justice Committee, will serve as basis in our determination of the sufficiency in substance. Now we proceed to the next ground. Please allow the chair to read. Article 6, other high crimes, pattern of abuse, threats, incitement, interference with civilian supremacy. The offenses specifically cited includes admission plus capability equals grave threat, pattern of conduct demonstrates willful subversion, incitement and public official responsibility, institutional harm, and public confidence. We open the floor for deliberation on the second ground, on the sixth ground,
Madam Chair,
the Honorable Dilemma.
this is my observation with respect to the sixth ground, the Article 6. I think it will now be unnecessary for us to further tackle and treat this ground as an article. And that goes through with respect to the last article, Article 7. Because as I was reading it, it's actually just a sort of a discussion, a summation of the discussions, the earlier discussions on the 5 grounds. Other high pattern of abuse, threats, incitement, interference with civilian supremacy. They refer to the same set of facts and allegations. The same is true with respect to Article 7. Article 7 says, pattern of abuse, cumulative misconduct doctrine, remedies, prayer, and verification. So these discussions are not strictly and technically discussions of grounds or articles. It's just really a matter of style that the drafter of this pleading thought it best to also include this in the discussions, but they need not be discussed, considered, and treated as separate grounds or articles. So for me, since there have been sufficient discussion already about the first 5 grounds in relation to also to our discussions yesterday with respect to the third complaint, I think this is unnecessary to further deliberate on this, because it's clear to me they need not be considered as articles, but just a discussion, a summing up, a wrap up. So I move, Madam Chair, to dispense with the consideration or deliberation on both Articles 6 and 7 for the reasons that I stated. I so move.
Second. Madam Chair, I second.
Before we act on the motion, let us put on record the manifestation of the Honorable Dilemma that the 6th and 7th ground are summation of the 5 prior grounds, and therefore the discussions that we had in the 5 prior grounds, including the discussions we had yesterday already with respect to similar grounds, support already the needed deliberation with respect to the 2 last ground, that is the 6th and the 7th ground. We state that to form part of the transcript of records of our deliberation today. So there is a motion to dispense with the deliberation of Article 6 and Article 7 for the purpose of the determination of sufficiency in substance of the 4th impeachment complaint. The same has been seconded. Is there any objection? Hearing none, the motion is hereby approved. The deliberation for the 6th and 7th ground are dispensed with. That concludes the deliberation for the determination of sufficiency in substance of the 4th impeachment complaint. Having said so, then the members are reminded to be ready to vote for the sufficiency in substance first of the 3rd impeachment complaint, followed by the 4th impeachment complaint.
Madam Chair.
Madam Chair.
Before we proceed, we recognize the Honorable Senior Deputy Speaker Ferdinand Hernandez.
Madam Chair, this is just a manifestation before we vote on the sufficiency in substance. At this juncture, it is important to clarify for the public what this vote means, and equally important, what it does not mean. Our vote on the sufficiency and substance of the impeachment complaint is not a determination of guilt or innocence on the part of the Vice President. We are not conducting a trial today, nor are we rendering a judgment on the allegations contained in the complaint. What the Constitution requires us at this stage is far more limited but nonetheless essential. The committee is merely determining whether the allegations, assuming them to be true for purposes of evaluation, are sufficient in substance to warrant the continuation of the impeachment process. If the complaint is found sufficient in substance, it does not mean the Vice President is guilty. What it means is simply that the process will move forward to the next stage, where hearings will be conducted, evidence will be presented, and the parties will be given full opportunity to be heard. After the proper hearings and evaluation of evidence, the House will then make appropriate determination, either to dismiss the complaint for lack of sufficient basis, or to elevate articles of impeachment to the Senate, where the Constitution mandates that the impeachment trial shall ultimately take place. To stress, our vote today is not a verdict of guilt, nor an act of condemnation. It is simply a decision on whether the constitutional process should move forward. The House is not an arena for trial by publicity, but an institution bound by due process, fairness, and the rule of law. Our duty today is simply to allow the process, as mandated by the Constitution, to take its proper course. In undertaking this duty, we assure the public that the process will be impartial, fair, and faithful to the Constitution, with full respect for the fundamental right to due process of all parties involved. In this way, we protect not only the rights of the respondent, but also the integrity of our democratic institution and the rule of law. Thank you, Madam Chair.
To form part of the transcript of record, since we are about to cast our vote on the sufficiency in substance of these two impeachment complaints, we would like to direct the committee secretariat to acknowledge the House members who are present at this hearing. Can you please register your presence in today's hearing? As the COMSEC call your names, this is in pursuit of transparency in the exercise of vote that we are about to take. Please call the names of the House members one by one and give them opportunity to at least register their presence.
Thank you, Your Honor. The Honorable Attorney Jervil Jinky Beatrix R. Luistro.
Present.
Honorable Mauricio G. Dumogan. Honorable Attorney Danilo Dani A. Domingo. Honorable Jennifer A. Lagbas. Honorable Alfredo A. Garbin Jr. Honorable Brian Poe. Honorable Jose C. Alvarez. Honorable Jonathan Keith T. Flores. Honorable Isabel Maria J. Zamora.
Present.
Honorable Aniela Bianca D. Tolentino. Honorable Arnie Lavin Roque. Honorable Franz Vincent F. Legaspi. Honorable Emilio P. Tanuatco III, Honorable King George Leandro Antonio V. Collantes, Honorable Ana York P. Bondoc, MD, Honorable Loreto S. Amante, Honorable Jose Joboy S. Aquino II, Honorable Joel R. Chua, Honorable Ernesto M. Junicio Jr., Honorable Arnan C. Panaligan, Honorable Lordan G. Suwan, Honorable Patrick Michael, Honorable Emerson D. Pascual, Honorable Munir M. Arbison,
May we encourage the House members to please use the microphone in registering your presence. Please.
Honorable Janice Degamo, Honorable Bienvenido M. Abante Jr., Honorable Jude A. Asidre,
Present.
Honorable Bernadette S. Barbers,
Present.
Honorable Rufus B. Rodriguez,
Present.
Honorable Chino Miguel D. Almario, Honorable Micaela Angela B. Swansing,
Present.
Honorable Ramon Rodrigo L. Gutierrez,
Present.
Honorable Maria Rene Ann Lourdes S. Matibag,
Present.
Honorable John Attorney J.P. Padiernos,
Present.
Honorable Terry L. Ridon,
Present.
Honorable Alan U.T., Honorable Rene Luis M. Co., Honorable Jose Manuel Tadeo Chel I. Diokno,
Present.
Honorable Sarah Jane I. Elago, Honorable Faustino Boji G.D. III, Honorable Ferdinand L. Hernandez, Honorable Janet L. Garin, Honorable Yaser Alonto Balindong, Honorable Francisco Paulo P. Ortega V,
Present.
Honorable Jefferson F. Konghun, Honorable Christine Singson Mihan, Honorable Christopher Shin P. Gonzalez,
Present with official copy of the letter of SDS Puno.
Honorable Beverly Rose A. D. Makuha,
Present.
Honorable Raymond Democrito C. Mendoza, Honorable Ryan S. Recto,
Present.
Honorable David J.J. C. Suarez, Honorable Ferdinand Alexander A. Marcos, Honorable Lawrence R. Defensor,
Present.
Honorable Julian Jam L. Baronda,
Present.
Honorable Marlene L. Primicias Agabas, Honorable Maria Alana Samantha T. Santos, Honorable Zia Alonto Adyong,
Present.
Honorable Ernesto M. Junicio Jr.,
Present.
Honorable Jazel Victoria C.U., Honorable Arnan C. Panaligan, Honorable Eliza Micaela Mica M. Gonzalez,
Here.
Honorable Marie Bernadette G. Escudero, Honorable Ivan Howard A. Gintu, Honorable Wowo Fortes, Honorable Hill Cabarangay Jr. Acosta, Honorable Adrian J. C. Advincula, Honorable Ana Victoria Veloso Tuazon, Honorable Crispin Diego D. Remulla, Honorable Vincenzo Renato Luigi R. Villafuerte,
Present.
Honorable Jose Bong J. Teves Jr., Honorable Monir N. Arbison Jr.,
Present.
Honorable Ramon Rodrigo L. Gutierrez, Honorable Eduardo R. Rama, Honorable J.C. Abalos,
Present.
Honorable Edgar R. Erice. Wala na, okay, wala na. Ito. Yeah, okay, wait, sorry. Honorable Presley C. De Jesus, Honorable Sergio C. Dagook, Honorable Kaka J. Bagao, Honorable Stephen James T. Tan,
Present.
Honorable Laila M. De Lima, Present. Honorable Percival Percy Sendanya,
Present.
Honorable Antonio L. Pino,
Present.
Honorable Jesus Manuel Bong C. Suntay, Honorable Journey Jet V. Nisay, Honorable Reynolds Michael L. Tan,
Present.
Honorable Shelo Crisel Lagman, and Honorable Walfredo Arman R.D. Magila Jr.
The chair understands. We acknowledge also, COMSEC, the presence of the Honorable Ilago, as well as the Honorable Bong Teves and the Honorable Joboy Aquino. The chair understands the difficult decision that the members are about to take. And with that, the chair commends the courage, the disposition, the candor of the members who are present right now to exercise this constitutional duty.
Madam Chair, point of inquiry.
What's the point of inquiry of the Honorable Padiernos?
Madam Chair, before we vote, may we get the guidance of the chairperson as regards to the complaints, wherein if you have multiple grounds and you agree to only some of them.
Under the rules, we will be determining the sufficiency in substance on the basis of the entire impeachment complaint. What is being determined is the sufficiency in substance of the complaint and not the individual grounds. We adopted the deliberation that we had in the prior impeachment proceedings, that is by going over all the grounds, only to give a better and wider perspective to all the justice members to come up with their individual judgment. With that, if the members have no other matters to raise, we shall proceed to vote.
Madam Chair.
Madam Chair.
The Honorable Rodriguez.
In the PBBM impeachment, we allow the Honorable Laila de Lima to also state that in one of the grounds, he concurs in one, and then the other, she would not. Because for example, this representation, Madam Chair.
If I may interrupt the Honorable
Yes,
Rodriguez.
please. Yes.
The disparity as to the position of the Honorable de Lima with respect to the first and the second impeachment complaint, but not with respect to the individual grounds.
I have clarified, but can we put on the records, for example, if, for example, in the third complaint, which we are going to vote on, what will happen if four of the grounds for example, in my case, just to be able to state, two of the grounds, there is substance. Four of the grounds, no jurisdiction, no substance. How will that be reflected, Madam
With
Chair?
all due respect, the chair has stated already that the rule provides the determination of the sufficiency in substance with respect to the impeachment complaint and not to the individual grounds. Again, we deliberated per ground only to give a better perspective to the justice members in the determination of the sufficiency in substance. In other words, we will be voting on the entire impeachment complaint and not on the individual grounds. And we are not conceiving as well the situation where the members will be manifesting a different position with respect to a respective ground of the impeachment complaint. With that, we shall proceed to vote. The chair is now ready to hear the motion on the sufficiency in substance of the third impeachment complaint, that is Father Sabalia et al. Impeachment complaint endorsed by the Honorable Congresswoman De Lima.
Madam Chair.
The Honorable Asidre is recognized.
Madam Chair, I move that we vote on the sufficiency of substance on the Sabalia et al. Complaint.
May we be given the opportunity to make it more accurate. We
Madam-
need to declare either sufficiency or insufficiency in substance of Sabalia et al. Complaint.
Madam
The
Chair.
Honorable Isidre.
Madam Chair, I move that we declare sufficient in substance the Saballa et al. Impeachment complaint.
There is a motion to declare the sufficiency in substance of Saballa et al. Impeachment complaint. The same has been seconded by the Honorable Tino and the Honorable Zamora. Do I hear an objection? No one is objecting?
Objection, Madam.
An objection has been registered by the Honorable Suntay, which means we will proceed to vote. Those who are in favor of the motion, please raise your right hand. Can you higher your hands just to make sure that the Secretariat will come up with an accurate counting? Secretariat, are you okay? Cong Dumogan is here and raising his hand as well. Oh, you may now put down your hands. Those who are not in favor of the motion, those who are not in favor of the motion, please raise your right hand. It's okay. Those who abstain, please raise your right hand. All right, so that concludes the voting. Secretariat, the result, please. For the record, the Honorable Renego just came and she's registering as well her vote for the affirmative. That is in favor of the motion. The vote of Arnan Panaligan is counted already per the Secretariat. With 54 votes in the affirmative, 1 in the negative, and 0 abstention, the Chair declares the sufficiency in substance of Saballa et al. Impeachment complaint. So ruled. Now we proceed to the 4th impeachment complaint, the Cabrera impeachment complaint endorsed by the Honorable Abante and the Honorable Ortega. The Chair is ready to hear the necessary motion.
Madam Chair.
The Honorable Rodriguez.
Before the vote, once again, I would like to ask. There are 5 grounds on the 4th complaint. This representation believes in the dismissal, no substance in 3, but 2 has substance. How do I vote?
Honorable Rodriguez, it is clear in the rules that we are voting on the entire impeachment complaint. The sufficiency in substance has to be determined on the basis of its entirety and not on the basis of the individual grounds. In other words, it's either you vote in favor of the sufficiency or not in favor of the sufficiency.
Madam Chair, I always agree with the chair.
Thank you. The chair is ready to hear the necessary motion.
Madam Chair,
The Honorable Zamora.
I move to declare the impeachment complaint filed by Attorney Nathaniel Cabrera as sufficient in substance.
There is a motion to declare the impeachment complaint of Cabrera sufficient in substance. Do I hear a second? The same has been seconded. Is there any objection?
Madam Chair, once again, objection.
The same has been objected to. We shall proceed to divide the House. Those who are in favor of the motion, please raise your right hand. Secretariat, are you okay? You may put down your hands. Those who are not in favor of the motion, please raise your right hand. You may put down your hand. Those who abstain, please raise your right hand. That concludes our voting on the fourth impeachment complaint. Secretariat, result, please. With 54 votes in the affirmative and 1 vote in the negative, with 0 abstention, the chair declares the Cabrera impeachment complaint sufficient in substance. So ruled.
Madam Chair,
The Honorable Zamora.
in view of the finding of the sufficiency and substance of the 2 impeachment complaints, I move to issue notice to the Vice President or the respondent of the impeachment complaints to file her answer to the impeachment complaints within a non-extendable period of 10 calendar days from receipt of this notice. Thank you, Madam Chair.
There is a motion for the issuance of notice to Vice President Sara Duterte for the filing of her answer to the 2 impeachment complaints within the non-extendable period of 10 days. Do I hear a second? The same has been seconded. Is there any objection? Hearing none, the motion is granted. The committee is directed to issue the necessary notice to the respondent. If there are no other matters to be discussed in this committee hearing or to be manifested by the members, the chair is ready as well to hear the necessary motion.
Move to adjourn, ma'am. Move to adjourn.
Our today's committee meeting is hereby adjourned.
Doon sa pinakitang video, sinabi niya nakakuha siya ng envelope, parte raw siya ng back, pero doon sa narration niya, in fact, meron raw bidding na hindi natuloy. So, para saan yung pera? Hindi rin naman pala natuloy yung bidding. So, si Usayas naman, sinabi niya, hindi siya, may nakuha siya, pero hindi naman daw siya membro ng back. Hindi rin sinaad kung ano yung pinagawa sa kanya. Sa bribery, kailangan ipakita ang quid pro quo. May binigay na pera o benefit kapalit ng specific official acts. Sa complaint, binasa natin to, hindi pinakita kung anong procurement decision ang allegedly binili. Hindi rin malinaw kung ang mga acts na ginawa ng DepEd officials ay hindi talaga parte ng kanilang regular duties. Kung ang ginawa ng official ay expected functions of their office, mahirap i-frame yon as bribery. Mas lalo pang lalabo kung ang allegation ay dahil sariling statement lang nung mga taong ipinakita. Kung hindi niya binuksan ng envelope, hindi rin malinaw. Kung may pera nga sa loob, kung magkano, kung anong laman, well, that was based on the statement of Mercado. Pero ang kailangan ipakita natin, meron bang ginawang kapalit? At saan nanggaling yung pera? Because there was just an assumption that it came from DepEd funds. Thank you very much, Mr. Chair.
Thank you, Congressman Suntay. Any other member who has a manifestation on as far as Article 4 is concerned?
Thank you.
Congressman Chua.
Thank you, Mr. Chair. Mr. Chair, we have discussed this issue thoroughly yesterday, and I think we should move on to the next ground. And I maintain my position with respect to Article 4. Thank you, Mr. Chair.
Thank you, Congressman Chua. Any other member? There being none, then we proceed to Article 5. Unexplained wealth, salon violations, bank records, and financial forensics. Any member who wishes to make a manifestation on this article?
Yes.
Congressman Rufus Rodriguez.
Mr. Chairman, here there is no statement. There is no proposition that one of the 6 grounds or more of the Constitution has been violated. Unexplained wealth is not in the Constitution. Salon violations is not in the Constitution. Bank records, financial forensics are not in the Constitution. However, let's take this. As probably I will now be able to assume, arguendo, that this may be to be able to support the betrayal of public trust. But Mr. Chairman, the problem with Article 4 is that there are absolutely no recital of facts constituting the offense charge because we don't even have the offense charge. There is no statement of either culpable violation of the Constitution. Second is treason. Third, Mr. Chairman, is bribery. Fourth is graft and corruption. Fifth is other high crimes. And sixth, betrayal of public trust. Nothing in Article 5 of this fourth impeachment complaint. So clearly, there is no recital of facts. How is there unexplained wealth? There is no statement that the Vice President received so much money and has deposited so much money, has acquired so much properties, that there is unexplained wealth. Because this is also defined under Republic Act 1379, RA 1379, which is the civil forfeiture of illegally acquired wealth. Nothing. Nothing on this. Also, there is no statement of which SALN violations. Because in the third complaint, it was the SALN from 2007 to 2017 as she was vice mayor and mayor. But nothing on SALNs from 2022 when she became president, vice president, June 30, 2022 up to now. Nothing. There's no statement here. So the second will again fall, the violations. Bank records. What bank records are you talking about? There is no attachment of any bank record or any statement of bank record. And then financial forensics. This is something that is a matter of evidence, not as a ultimate statement of facts. So therefore, Madam Chair, that is why, you see, that is why they are requesting, if you go to page 59, look at this. This is not a recital of facts. What does it say? It's 59. 247 paragraph. To determine the existence and extent of unexplained wealth and sal-in violations, I respectfully request, Attorney Cabrera, respectfully request that the Honorable House of Representatives, through the appropriate committee, take the following actions. Issue subpoena. We are not yet there. The only problem with this is a clear request for a fishing expedition against the Vice President. So very clear. In Article 4, there is nothing that recites facts that will lead us to say that there is a sufficiency of substance. And therefore, very clear, what do they ask here? To order preservation of vault inventories. Can you imagine that in this particular proceeding already asking for us to fish? And then we also authorize coordination with COA, the Bureau of Internal Revenue, Anti-Money Laundering Council. But they have to first recite the statement, ultimate facts constituting. There is none, Madam Chair. So therefore, clearly, this particular, by a very face on the face, in the four corners, under positive law, where you can only look at the four corners, like in this case on finding substance, we have to look at the statements in the four corners of the document. And there's nothing there about all of these allegations. So therefore, Madam Chair, Article 4 as Article 5 as Article 4 false. There is no sufficiency in substance. Thank you, Madam Chair.
The Honorable
Chair.
Po and then the Honorable Suntay.
Madam Chair, of course, with due respect
Madam Chair,
to the previous
may I be
speaker.
allowed to answer after Congressman
Yes,
Suntay?
you will be called after the Honorable Suntay.
Madam Chair, with due
You may
respect
proceed.
to my colleague and someone I believe is very knowledgeable when it comes to the law and the Constitution, I'd like to cite that Article 11, Section 17 of the Constitution is clear that public officers are required to file a true and complete statement of assets, liabilities, and net worth. And this is not a minor administrative requirement. It is a constitutional duty grounded in public accountability. So at this stage, our task, Madam Chair, is quite limited. We're not determining guilt, and we are not conducting a forensic audit. We're deciding whether the allegations are ultimately true. So we are determining sufficiency and substance. And what I have noticed and what I have observed here in this complaint is that as our honorable colleague has mentioned, there seems to be no salin copies, no bank records, and no forensic financial reports attached to this complaint. However, I wouldn't say it's a fishing expedition. So if I may ask some points of clarification to our sponsor, our colleague, Rep. Abante, I'd like to ask...
The endorsers' attention are invited regarding questions to be raised by the Honorable Po.
To further give, I guess, light to this issue, may I ask what specific transactions, properties, accounts, asset increases are being cited indicative of unexplained wealth? Or maybe are there particular salin years where material omissions were alleged?
May we hear from our endorsers?
Well, to add, Madam Chair, the complaint narrates that the forensic records of the VP reveal glaring discrepancies as to the inflows and the transfers of funds in her banks as compared to her declared income in her SALN po. These discrepancies do not account by any lawful income or declaration of gifts, thereby giving the rise for reasonable inference or originated from illicit resources, Madam Chair.
You are referring to the income of the Vice President vis-a-vis what appears in her account. Honorable Ortega, may we hear your confirmation?
Yes.
Madam Chair, which account? Which bank records? Because we are here, ultimate facts. Which bank account, which bank record are we talking about here, if it's stated here? Because I have read this thoroughly 3 times already, and I did not see any.
Madam Chair.
Yeah, but maybe ask first. our endorser. Because we have to have ultimate facts. When you say bank records, then you have a duly authenticated bank statement given by the bank.
With all due respect to the Honorable Rodriguez.
Yes, ma'am.
Let us all be reminded of the bank secrecy law. While the bank account is significant, I think we are not in the position to expect the complainants to provide specific details of these accounts in view of the bank secrecy law. And we all understand that impeachment proceeding is the only avenue by which the complainants may be able to look into this and perhaps avail of the documents necessary to support this specific ground. That is for the record. The honorable endorsers are recognized to respond to the Honorable Rodriguez.
Therefore, the need for forensic financial review, Madam Chair.
Madam Chair.
Let's go back to the Justice member who raised this question. The Honorable Po is again recognized.
So continuing on that point and manifestation, since there are no documents or bank records that could be cited, was there maybe any sworn testimony, public disclosures, audit findings, financial statements, or comparative SALN data over the years that may have been used as the basis for this ground?
The Honorable Po is asking about the specific documents or evidence in support of the fifth ground of the fourth impeachment complaint. That is in view of the bank secrecy law. What therefore are the evidence so far attached or considered in support of the fifth ground of the fourth impeachment complaint?
Madam Chair, it would not be automatic for us to be able to tell those banks no because of the bank secrecy law. That's the reason why itong pinag-uusapan natin, yung impeachment complaint na ito, lalabas po ito sa trial. We are not yet in the trial. We are just talking about the sufficiency of substance dito. Meron bang sufficiency of substance na pinag-uusapan natin? Meron. But in everything in this, I would like to tell our colleagues here, no, na this will all come out in the trial, in the impeachment court. You see? Yun po ang nais kong sabihin sa lahat.
The Honorable Rodriguez.
In answer to my good chairman, the Committee on Human Rights, there has to be a recital of facts. And in a recital of facts, there must be a reference to testimonies about bank accounts, if we cannot get the bank accounts. In other words, there has to be a nexus of the statement about irregularity in SALN and bank records by having itself the bank records, the SALNs. And so therefore, it is totally devoid of any particular recital of facts, because that is what we need. We cannot go further if there's no recital of facts constituting the offense charge. Because in fact, the statement of Honorable Brian Po that there is a requirement in the Constitution of SALN, whatever it is not in the six. To construe the constitutional provisions, you are very much limited to the enumeration. Use them generis. If it's not in the it's not in the enumeration, it cannot be a ground. So again, culpable violation of the Constitution. Second, treason. Third, bribery. Fourth, graft and corruption. Other high crimes, bitter public trust. No statement about having an inaccurate or untruthful SALNs as a ground for impeachment. So that is what we have. We have to therefore have that. So just to be able to respond to the statement that there is a violation of the Constitution that is culpable. It is not, Madam Chair. In fact, those in the SALN can even be able to reform and refile a corrected one, Madam Chair.
Madam
The
Chair.
Honorable Defensor.
Madam Chair.
And
Thank
then
you.
the Honorable Abante.
Thank you. Madam Chairman, the most democratic way to settle this, whether there is a recital of facts or not, is to follow the rulings of the Supreme Court that in impeachment proceedings, each member is allowed to decide for himself how to appreciate the recital of facts or the evidence. And the best way to do that is by voting later on. So let's proceed and let's not stall anymore. Thank you.
We invite the
Chair.
attention of the members to the manifestation of the Honorable Defensor. There is no quantum of evidence required in determining the sufficiency in substance. And in the case of Merceditas Gutierrez, it has been upheld by the Supreme Court that the decision rests to the exclusive judgment of the individual
Yes.
members of the Justice Committee.
Madam Chair.
I think that rests our discussion
Madam Chair.
on
let me
this
just-
specific ground.
Let me just answer.
The Honorable Abante.
As an endorser, no, let me just answer the statement of Congressman Rufus. Of course, not being a lawyer, but of course, a very good student of law, no, legal doctrine, as explained in the case of Gutierrez, nabanggit na kanina, no, versus HOR, Committee on Justice. An impeachment complaint is sufficient in substance when it recites facts that, assuming their truth, constitute an impeachable offense and are determinative of the committee's jurisdiction. Yun po yung binanggit kanina ni Congressman Lawrence. It is not yet a full-blown trial on the merits. Because sufficiency in substance, as has been said, requires a recital of facts that, assuming their truth, sapagkat lahat po ito allegations pa lang eh, assuming their truth constitute an impeachable offense and establish the committee's jurisdiction. Therefore, an impeachment complaint that is conclusory, fact-bare, or effectively unsupported despite verification is vulnerable to being found insufficient. Yun po ang gusto kong sabihin, no? Now, pinag-usapan yung recital of ultimate facts dito. The fourth complaint that we are endorsing is sufficient in substance because it does not rely on mere constitutional labels or generic accusations as accused by Congressman Rufus. Hindi lang ito basta nagsabi ng betrayal of public trust or culpable violation ng walang detalye sapagkat nakalagay na po lahat eh, di ba? Instead, it pleads a concrete recital of facts constituting the offense charge and determinative of the committee's jurisdiction. Sa madaling salita, may malinaw na salaysay na mga pangyayari, may petsa, may halaga, may dokumento, at may testigo. Hindi ito puro haka-haka o opinion lamang. So in particular, the complaint alleges a public admission on 23 November 2024 regarding contracting an assassin, for example, together with the Alice non-retraction and reiteration of that statement. It situates these allegations within their factual context, security implications, legal theory expressly invoking